Contracts of insurance are binding legal agreements and are enforceable by law. A policy is a written contract in which one party promises to indemnify another against loss that arises from an unknown event. A policy rider or endorsement is a legal attachment amending a policy. Additional benefits or a reduction in benefits are often incorporated in policies by the attachment of either a benefit or an exclusion rider. Regardless of the insurance type, the policy owner pays premiums in exchange for the insurer's promise to pay covered claims. For a contract to be legally valid and binding, it must contain certain elements: offer and acceptance, consideration, legal purpose, and competent parties. A contract agreement involves a meeting of the minds, a definite, unqualified proposal offered by one party, and the acceptance of its exact terms by the other. The offer of an insurance contract is made by the applicant when the application is submitted with the initial premium. The insurance company accepts the offer when it issues the policy as applied for. When an offer is answered by a counteroffer, the first offer is void. Consideration is the value given in exchange for the promises sought. The applicant gives the premium and completed application in exchange for the insurer's promise to pay benefits. It also contains information such as the schedule and amount of premium payments. The object of the contract and the reason the parties enter into the agreement must be legal. Insurance contracts are always considered to possess a legal purpose. The insurer is considered competent if it has been licensed or authorized by the states in which it conducts business. The applicant, unless proven otherwise, is presumed to be competent with three possible exceptions: minors, the mentally infirm, and those under the influence of alcohol or narcotics. Each state has its own laws governing the legality of minors and the mentally infirm entering into contracts of insurance. These laws are based on the principle that some parties are not capable of understanding the contract. There is an element of chance and potential for unequal exchange of value or consideration for both parties. The benefits provided by an insurance policy may or may not exceed the premiums paid. Both insurance and gambling contracts are typically considered aleatory contracts. A contract of adhesion has been prepared by one party, the insurance company, with no negotiation between the applicant and the insurer. The contract can only be modified by the insurance company. The applicant adheres to the terms of the contract on a take-it or leave-it basis when accepted. Any ambiguities or confusing language in a contract of adhesion involve legal interpretations affecting contracts. Only one party, the insurer, makes any kind of enforceable promise. Insurers promise to pay benefits upon the occurrence of a specific event, such as death or disability. The applicant does not even promise to pay premiums. The insurer cannot require the premiums to be paid, but has the right to cancel the contract if premiums are not paid. The owner person of the property is insured, not the property itself. Life insurance contracts are not personal contracts. The insurer's promise to pay benefits depends on the occurrence of an event covered by the contract. The insurer's obligations under the contract are conditioned on specific acts by the insured or the beneficiary. Both the policy owner and the insurer must know all material facts and relevant information. There can be no attempt by either party to conceal, disguise, or deceive. Insurance applicants are required to make a full, fair, and honest disclosure of the risk to the agent and insurer. Reasonable expectations reinforces the rule that ambiguities in insurance contracts should be interpreted in favor of the policyholder. It also states that an insured is entitled to coverage under a policy that a sensible and prudent person would expect it to provide. Warranty. A statement made by the applicant that is guaranteed to be true in every respect becomes part of the contract, and if found to be untrue can be grounds for revoking the contract. They are presumed to be material because they affect the insurer's decision to accept or reject an applicant. A warranty can be either express or implied, and may relate to the past, the present, the future, or to any or all of these. Representation. A statement made by the applicant that they consider to be true and accurate to the best of their belief, are used by the insurer to evaluate whether or not to issue a policy. Unlike warranties, representations are not a part of the contract and need to be true only to the extent that they are material and related to the risk. Statements made by applicants for insurance are considered to be representations and not warranties. Cannot qualify an express provision in a contract of insurance, but it may qualify an implied warranty. A false statement made by an applicant that would influence an insurer in determining whether or not to accept the risk is considered a material misrepresentation. Concealment. The failure or neglect by the applicant to disclose a known material fact when applying for insurance. If the purpose of concealing information is to defraud the insurer, that is, to obtain a policy that might not otherwise be issued if the information were revealed, the insurer may have grounds for voiding the policy. Whether or not concealment is intentional or unintentional, the injured party has the right to rescind the insurance contract, make the contract null and void. Materiality means, would the insurer have issued the exact same policy, with the exact same terms had they have known the concealed facts at the time of application? The insurer must prove concealment and materiality. Void versus voidable contracts. Void contract. An agreement without legal effect is missing one of the elements specified by law for a valid contract. It cannot be enforced by either party. An insurer may void an insurance policy if a misrepresentation on the application is proven to be material. Voidable contract. An agreement that, for a reason satisfactory to the court, may be set aside by one of the parties in the contract. Legally binding unless the party with the right to reject it wishes to do so. An insurance contract is voidable. The insurance company has the right to cancel if the policy owner stops paying the premiums. The voluntary act of terminating an insurance contract is called cancellation. Fraud. Under most contracts, fraud can be a reason to void a contract. Under some types of insurance contracts, an insurer has only a limited period of time, contestability period, to challenge the validity of a contract. After that period, the insurer cannot contest the policy or deny benefits based on material misrepresentations, concealment, or fraud. Parole evidence rule. Parole evidence is oral or verbal evidence, or that which is given verbally in a court of law. The parole evidence rule states that when parties put their agreement in writing, all previous verbal statements come together in that writing, and a written contract cannot be changed or modified by parole oral evidence. Waiver. To voluntarily relinquish or abandon a known right under an insurance contract. Protects the consumer if an insurer waives its rights under an insurance contract. If an insurer fails to enforce, waives a provision of a contract, it cannot later deny a claim based on a violation of that provision. Estoppel, the loss of defense, protects an insured if the insurer or its producers make an error, and later the insurer attempts to deny a claim. Protects an insured if the insurer or its producers make an error, and later the insurer attempts to deny a claim. Agent as a fiduciary. A fiduciary is a person who holds a position of financial trust and confidence. Agents act in a fiduciary capacity when they accept premiums on behalf of the insurer or offer advice that affects a person's financial security. Subrogation. Subrogation is the right for an insurer to pursue a third party that caused an insurance loss to the insured. Subrogation is used to recover the amount of the claim paid to the insured for the loss. Insurance agent errors and omissions. Professional liability insurance. EMPO insurance is professional liability insurance for insurance agents. The insurer agrees to pay sums that the agent legally is obligated to pay for injuries resulting from professional services that he rendered or failed to render. Offered in the following types: life agents, accident and health agents, property and casualty agents. Typical losses covered for the producer under an EMPO policy include not providing insurance coverage when the agent was supposed to, creating an administrative error, premium calculation errors, misstating insurance coverage, not effecting a policy change requested by the customer, not explaining the policy provisions properly, incorrect identification of client loss exposures, forwarding inaccurate or incomplete information about a client to a carrier, failing to recommend coverage, not handling a claim properly, common exclusions, intentionally harming others, criminal acts, illegal acts, dishonest acts, malicious acts, libel, slander, and the intentional violation of any law, regulation, statute, or ordinance. Tort law? Provide full compensation for proved harm. Tort law involves the concept of righting a wrong done to a person and provide relief from the wrongful acts of others by awarding monetary damages as compensation. Most civil court claims fall under tort law. Lawsuits involving contracts fall under contract law. Valued or indemnity. Valued contract pays a stated sum regardless of the actual loss incurred. Life insurance contracts are valued contracts. Indemnity contract pays an amount equal to the loss. Attempts to make the insured whole again return the insured to their original financial position. Should not make the insured better off than they were prior to the loss. Accident, health, and property insurance policies are examples of indemnity contracts.